In many ways, the squatter is like the illegal immigrant and the homeless vagrant. Take your possessions, home or business, get into the property, scam you into a place no matter how, and won't leave. Oddly, they can have no regard for the owner, and they can threaten you if you touch their property in your home when their ownership comes into question. There is growing crisis of tenants and scammers that are moving in on unsuspecting homeowners. They occupy the home and refuse to leave when asked. Ladies and gentlemen, our legal system has managed to circumvent the homeowner's rights in favor of the tenant, regardless of an owner's circumstances. The homeowner can sustain enormous financial losses and have no recourse in law to use their own paid-for property. I have with me to talk about this subject Wesley Martin, who's a paralegal and landlord tenant specialist, and also does work for the Americans for Legal Reform. Welcome, Wesley.
Good evening, Chris.
Okay, so based on the opening, I just want to say one more thing before we can get into your questions, that crooks and scammers are in the midst, and I've done home invasion programs before. It's not just landlord-tenant, but it's also homes. And that miscreants and deviants will take advantage of anyone, no matter how good they are. And in their homes, they will take advantage of you. I've hosted 4 programs. No deed goes unpunished. So with your credential, and you have plenty of following, because I've heard a lot about the work that you do, tell us about how you got the credential you did and what made you get into this.
Well, there came a time when I rented a house to my sister and her new husband, and when it came time for them to pay us the rent, my brother-in-law marched up my driveway with his arms folded and said, "We're not paying anything." And I was kind of shocked by that, because we had gotten the house through the family and we had given my sister a very favorable rental rate. And then I'm suddenly now confronted by my brand new brother-in-law, who decides that it's not my home but his. And so I went out and sought an attorney, and the attorney charged me an enormous amount of money. He won the case, and I mean, by today's standards, his fee was probably in excess of $8,000 to do an eviction, which is wildly overpriced.
Right.
He succeeded in getting the settlement, and after that point, my sister and my brother-in-law paid their rent punctually for several years on time after that. But I forced myself to learn the procedures, having been charged an enormous amount of money, more so than I would have had to pay in law school, I think.
Isn't that amazing?
And so I made it my business to learn the ins and outs of landlord-tenant practice, and it is a small area of law. It's a very specialized area of law that not a lot of attorneys go into. Oftentimes, a landlord will call upon their divorce attorney. Oh, I got a tenant to get out, for example, and the divorce attorney is not familiar with all the little ins and outs of landlord-tenant practice, and they will struggle to perform and get a success out of it. So my mission, having learned how to do it, is to make sure that people who won't or can't afford an attorney can represent themselves in court.
With your aid?
With some assistance from myself, and based on my knowledge as a landlord and as a litigator, we guide them to the proper cues and the particularities of the court, because the cases in landlord-tenant court, Chris, are really not that complicated. They come with a variety of causes and beginnings, and then you have to assess your situation and make a decision about what type of a landlord-tenant proceeding you want to do, and then follow through and do the forms correctly and be polite in court and know what's going on in court.
Isn't it kind of a shock for the homeowner to even recognize that they're being either scammed, or that the tenant isn't going to pay, or they're not cooperating in some way to make it a miserable condition for the landlord?
Well,
when do they recognize it?
When I'm approached by a landlord and asked to give them some guidance, oftentimes the landlord is a very kindly person, and as you're in your introduction, no good deed will go unpunished.
Right.
Everyone is on their best behavior when they move in. They're not on their best behavior when they move out. And I try to keep to the philosophy that bad things happen to good people, including tenants, including landlords. And so when a tenant is having difficulties on their own, that problem often visits the landlord in the form of not paying the rent or some other disturbances and events in the house that the landlord can no longer tolerate.
Do you know that in your experience, or have you seen people do this over and over again, or have you bumped into incidences where somebody that you took care of at one other time is now in the same situation?
I'll give you the answer is yes. There are a goodly number of people that do this on a regular basis. They are known to the Suffolk County Sheriff and the Nassau County Sheriff, and they move from one landlord to another. I had a situation where when I was first doing an eviction on this particular family in Bayshore, I had to get past the dog, and the dog was ravenous to bite me and kill me. And they eventually moved out, and then they moved to another house, and the new landlord called on me and said, I got these people in my house, and it was the same people a year later, and this time the dog barked a lot, but he didn't try to attack me. And the people moved out of that house. We got him out of there. And then the third time, another landlord called me, and it was the same people. And this time the dog let me pet him. So we know the game. We know the game that they play. And I advise the landlords to stick to the legal process, because the constant question is, how can I get these people out of my house? And my answer is always, as soon as you do it correctly the first time.
You know, we have to follow anyone who doesn't know, and let me tell you, there's going to be a lot of people out there who don't know that these things happen because they don't really bump into it. They may hear about it, but they don't pay any attention to it because they're not in the soup. They're not really actually dealing with it. When it actually happens, it not only comes as a shock, but all of a sudden you recognize that your own property is no longer utilizable. Utility.
Usable.
Well, usable, okay. The utility is now gone out of what was once a purposeful home life condition that you purchased your house for. You know, how does that land for you when you, the guy who's calling you is, you know, that you got to expect some anger.
There are, well, I'm constantly dealing with very angry people. The landlord is angry at the landlord, the landlord is angry at the tenant is angry at the landlord, and everybody is mad about everything. But what I say to landlords is that once you have given the key to the castle to your tenant, whoever they may be, you're literally giving away 9/10 of your rights, because you are giving them possessory rights. And once you do that, it can only be undone by a court order.
So in other words, because you don't have that spelled out in any way by any document or any contract, it's limitless that their conditions be met in any which way they want to, other than physical ownership. But right? I mean, this.
Well, Chris, the landlord-tenant relationships are basically divided up into two groups: one with a lease and one without a lease, or what is called an oral agreement. And the oral agreements are enforceable, but it's not as plainly stated in terms of when the rent is due and how much the rent is, and other terms, conditions, and limitations that are clearly spelled out in a written form. And again, it's a matter of good taste and personal preference whether or not the tenancy is created by a formal lease as opposed to an oral agreement. Most of the big real estate conglomerates, where they have thousands of units, rely exclusively on written leases because they're in a volume situation, whereas an individual that's renting a basement apartment to the cousin of a friend of a daughter of an aunt, they're not getting into all of the written formalities. They're doing it on an understanding and on good faith, and most of the times that that leap of faith is honored, and in some very difficult situations it's not. And it's sort of like the fire department. They're all there with their shiny trucks, but you don't call them unless you're seeing smoke and flames.
I'm talking with Wesley Martin, who's a legal reformer, paralegal, and does work for landlord tenants. What kind of damages can be claimed by a landlord who suffers damages in these kinds of conditions where somebody's in your home?
Well, the question that I ask the landlord, and I ask it religiously, is where do these people get their money to pay their rent? And you would be amazed at the variety of odd answers I get. Well, I don't know where they work. I think they get DSS. I think they get Section 8. I said, you think is not an answer to be given in court. All right, because a court wants to be able to evaluate the essential elements of the tenancy. So if a landlord is doing his job, he's going to get a job reference, he's going to get a copy of a couple of paychecks, he's going to get a driver's license, he's going to do a DMV check, he's going to do a credit check.
Except when there's friends. That's the right thing to do, you're saying.
The normal business-like way to do
Right.
it would be to do a complete set of checks and verifications on the person that you're allowing into your home. But again, the unsophisticated homeowner may not engage in that because they're either renting to a distant relative or a friend.
Asking somebody to stay over for a while their apartment's getting ready or something like that.
And then the apartment never gets ready.
Yeah, and that's what does happen. So, but in terms of damages, like if there's anything that happens to the place that you can identify wasn't there before, everything's working before, and then suddenly things aren't working.
Well, I'll give you an example, Chris. Yesterday I got a frantic phone call from a homeowner that is engaged in an eviction action, and he reported to me that the tenants upstairs turned all the faucets on and flooded the tenant downstairs with a foot of water. And now what am I going to do? I said, well, you're going to call the police and you're going to make a report, but the police also have limitations. If they do not see the event taking place, if they don't see the people outside tossing the bricks through the
Then
front
they just
plate,
become secretaries.
well, they're going to make a report that say there was an incident, that there was a
Right.
complaint, but they cannot arbitrarily arrest somebody unless there is clear evidence in front of the eyes of the officers as to what damage actually took place. So even though you know that the tenants are the only people that are living in the building, and you know that you're not doing the damage, and you know the cops aren't doing the damage, it's logical to assume that the tenants did the damage because they live there. But if you didn't see it happen, you're just going to have to repair the damage after they're gone.
Wow, that's a minus out procedure. In other words, it's just
It
you
can
just
be
take
very
the lesser
expensive.
word. Ooh, that's really. Let's talk a little bit about the course that one might take when it gets to court. So, let's say that somebody's turning. You ask for. There's a document process. Give us the document process.
Well, in the typical non-payment proceeding, which is about 90% of eviction actions that I've seen over the last 20 years, it's basically an argument about money. Either the rent is too high, or they're changing the rent, or they can't afford the rent, and they're late with the rent, or they're sporadic with the rent, or they just refuse to pay. You now have a question to raise in court about a promise that was made when they moved in. They made a promise to pay the rent, and you made a promise to give them a livable premises. So somewhere along the line, when the money stops, there's a reason for it, and the practitioner and the landlord together are going to have to determine what the cause was of this stoppage in the rent. There are many reasons that happens. One, I lost my overtime. I'm in the middle of a divorce. I got fired from my job. I'm terminally ill. I mean, there is a variety of things going on. We encounter, or I've encountered drug dealing in houses. I've encountered physical fights going on, gang activities going on.
Mm-hmm.
There's a wide variety. So starting out with most of the cases are arguments about payment of money, and those are non-payment proceedings. And there's a set of forms that are used to bring a proper non-payment proceeding. And those are basically Blumberg forms or Office of Court Administration forms that are given out at the courts, or sometimes narrative forms that are available online. And I caution people not to be too free with
The selection of a document.
The basic forms are a notice of petition, which is a one-page form, and a petition, which is another one-page form. And the notice basically sets forth the names of the parties that are litigating, meaning yourself as a landlord, and your tenants' names, if you remember or know them, and then the type of proceeding, the location and address of the court where you're going, and the date that you're going to court. And then that document has to be issued by either an attorney or a clerk or a judge.
Does it change anything if if there's two parties in the home and one of them didn't say that they received the notice?
Well, then you're going to rely on on your process server.
Yeah.
You're going to rely on your process server to make sure that the papers are properly served, and that's a whole nother science in itself.
If it comes in the mail?
It can come in the mail. The normal procedure is that you go personally to the house, and you knock on the door and you bang on the windows.
Process server.
And your process server, and I am a process server. I've done this all my life. You have to make the physical attempts. If after the third visit they are either refusing to answer the door, or they can't answer the door, or they're out of state or somewhere incarcerated, then the law allows the papers to be affixed to the front entry door of the premises, and then the follow-up first class and first class certified mailings have to be done to each of the named tenants in your caption. So they can contest it all they want to, but the process server will produce a sworn statement that he did that, and it's filed with the court, and it is part of the case. And if there is a mistake made or some omission on the part of the process server and it gets caught, then obviously that would be subject of a separate hearing to determine whether or not the court is satisfied that you delivered the papers to the tenant. Now, I had a tenant's attorney challenge me one time in court in Lindenhurst. He said to me, "Mr. Martin, you have to prove to me that they got the papers." And I said, "You need to step back a couple of feet, counselor. I don't have to prove they got them. I have to prove I sent them. Whether you got them or not is of no concern to me whatsoever, but I can prove to the satisfaction of the court that I sent them."
You keep receipts of everything that you send?
We keep very, very heavy documentation. We take Xerox copies of the envelopes, the documents inside, certificates of mailing, certified receipts, certified mail receipts, and we attach them to the affidavits so that there is very little question about what we did on our end to make sure that the tenant got the papers.
Does it make much of a difference if there's a lease or not a lease? We're just going to follow up because we've got about 5 minutes left.
Okay. No, the same principles apply whether there is a written lease or an oral agreement. The main difference is that if it is a written lease, then it's set forth in writing, it can be produced as opposed to merely testified to.
Right, so that's a game that's already, the game plan's already in motion if you have some kind of lease. If you don't have a lease, then it's basically my word against yours, or your word.
No, you're making a sworn statement on your petition as to the identity of your tenants, the identity of yourself, your status as an owner or a landlord, the address of the property, the portion of the house that they're occupying, and what defaults in payment of rent are set forth, for which months, and the totals. And that's really only a 6-sentence case. It's not an OJ murder trial with DNA.
Right.
It's a fairly boiled down and simple process.
Mm-hmm. Is there such a thing as responding to? Do you have to get involved if one of the people, the landlord, complains that the tenant's harassing them, or is there an order protection issue or anything that's like that you can have recourse over?
Well, who are you asking has the recourse?
The landlord, if there's threats made.
It happens.
By the tenants.
It happens occasionally where criminal action is taking place in the house, particularly in the area of drug dealing. And when there are drug arrests in the house, in Suffolk County anyway, the county attorney will send you a notice informing the landlord that a drug-related arrest has taken place, and that if they don't take some action to solve this landlord-tenant behavioral problem, the county is empowered to seize the house from the landlord. Then we get the frantic call from the landlord.
Yeah, it's just crazy. It's just absolutely crazy.
Well,
it's amazing.
Most landlords and tenants get along, all right? But when they don't, it becomes very, very loud and very, very noisy, and you can visit any of the district courts in Lindenhurst on Tuesdays, in Patchogue on Wednesdays, in Huntington and Ronkonkoma on Thursdays. You can go into the Nassau courts in Hempstead and watch this happen, and it's quite an education.
I'll bet. Should really take a look at that. So let's go one more step into into any recourse issues. The landlord is going to obviously be upset about their situation if the tenant is not cooperating, making a mess out of the house and doing damage on the inside. What is it? Is there a difference? First question number one: is there a difference between somebody who has that kind of damage and is in a lease situation, or is there a difference when someone doesn't have a lease? When there's damages that need to be dealt with somehow?
Well, the damages have to be documented, whether or not you have a written lease or an oral lease. So the documentation process is very important.
Is a picture enough?
It starts with when they move in, that you're taking pictures of them moving in, that you have an indication of the conditions that they moved into. Normally, a written lease says it's as is, whatever you see, you get. And then at the time when they immediately leave, another set of photographs is always advisable so that you can see the before and after. And if there's a question about amounts of money needed to repair that need to be brought before a court, the court is going to be able to also see the before and the after for themselves, because the court cannot imagine things. The more assistance you give the court to see the difference between the before and the after, the easier it's going to be to...
Picture seems the only way to do that.
Picture is worth 1,000 words,
yeah,
Chris.
What about something in writing? I mean...
Well, the damages that are incurred could be as little as a repaint job, which is a standard thing you have to do anyway, or changing carpets when the pets damage the carpets and they're no longer
well, let's say
usable.
It's a little bit more serious than that.
We have encountered holes punched in walls, massive graffiti, broken appliances, stolen appliances. And basically, when you're calling the fire department, you're calling them to put the fire out. When the landlord is calling me, he's calling me to get the tenants out. And so getting back your property takes a big mental strain off of yourself, regardless of the damages. And the reason is that you have to pay for the damages either through your insurance company, if you have coverage of any sort through your homeowners. You have to do it eventually anyway to make it livable again.
Can you claim, excuse me for interrupting you, but can you claim to the insurance company that none of the damage was created by you?
Well, it really depends on the policy and the individual insurance company and what your coverage is. I always advise landlords to make sure that when they are insuring their property, that they state that it is an investor property, that it is not owner occupied, but that it is tenant occupied, because it will be a very easy out for the insurance company to say, well, you told us that this was an owner occupied house, and now you're telling me that the damage is done by a tenant. Sorry, we're not covering that. So you have to be honest with your insurance carrier. They charge a little bit extra for the tenant-occupied policy. It's well worth the money.
Well, one more thing just added to that, because it reminds me. what about the possibility of when the damage has occurred, right? You already have some damage, you sustained damage in the house, and you have insurance, so you contact the insurance company ahead of time to view the damage while the tenants are still there.
Well, now you're getting
I mean,
up.
I know.
Well, now you're getting
But
into
it's an
odd.
interesting question, isn't it?
Well, the tenants
That's
have,
my job, Wes.
That's okay. The tenants have possessory rights, and if
Yeah.
they don't want to let somebody in, unless they're looking at a man at the front door with a gun in his hand and a warrant signed by a judge, they don't have to let anybody in.
What if I'm there? What
So-
if I'm the landlord? I'm sorry, the landlord.
Well,
says
do you
yes.
mean you're living in the house, or do you mean that you are not living in the house?
That's a good question. Either one.
Well, if you are living in the house, you're allowed to let someone into your home, but only to the extent that it does not intrude into the space occupied by the tenants. All right, that's an important distinction.
Okay. Yeah.
And if you are not living in the house, then you have to rely on the good grace of the tenants to
How do you
allow
think
them.
that's going to work?
Well, that depends on what's broken. If their stove is broken, they're going to let Sears in to bring them a new stove. No problem there. All right. So it's really a common sense equation.
Yeah.
But again, when you call me, you're calling to get the tenants out. You're not assessing whether they're going to pay you the old rent or whether the judgment is going to be enforceable or what have you, because those are secondary issues to getting you back your most valuable asset, which is your home. That is the mission.
So the homeowner.
Everything else is secondary.
So your job is to get the homeowner
back into possession.
back into his home, back into possession. That was a wonderful idea. It's amazing that you have to go that far, right? Okay, in the last minute or two that we have here, is there anything you want to say that you might want to give as information that would lead to what a landlord tenant should be considering when they're renting?
Well, I guess at the top of the list is, regardless of who you're going to rent your home to, you need to do a credit check, you need to do a criminal check, and you need to do a DMV check. Now, the credit check is only a $25 or $30 expense. Any real estate broker with a license can conduct it for you with the permission of the tenant-to-be, which they have to give you, otherwise hit the road, Jack. And the second search is a criminal search, which you can do in the criminal courts in either Nassau or Central Islip. They are free. You do a name check and see whether these guys are murderers or they just got out of prison or whatever. And the third and final thing is a DMV check, which is a license check. You get a copy of their driver license and you bring it up to the DMV and you pay $10 and you get an abstract and see whether or not they pay their insurance on their car. Because if they don't come to you with paid up insurance, they're going to give you problems right away when they move in.
Why would that be? Did I miss something?
Well, because if they don't have insurance, that means they're driving illegally. If they don't have a car, you don't need them in your house, because where are they going to get the wherewithal to go to work unless they're a commuter on the railroad? All right, so these are clues. They're not absolute standards, but they're clues to tell you how reliable the tenant is going to be. A reliable tenant with a job and a car and a history of renting that's not blemished by non-payment.
That's what you're looking for.
And that's where the credit check comes in.
Yeah. Anything else in the last minute?
Well, I always tell people that the credit check is not a do or die situation. If you get a credit report on an individual that has an $80,000 bill to Columbia Presbyterian Hospital because they did a heart transplant, that is not something that should kill their ability to come into your home. Whereas if they had a judgment for $6,000 against one individual, they had a $4,000 judgment against another individual, they had a $16,000 judgment against another, brought by another individual, that's a clue that they're cheating their landlords, and you don't need those people in your home.
So those are judgments against them. Well,
Yes.
Wesley Martin, you took a good deal of time, and thank you very much for all the effort that you did. We covered everything that I had to cover, and we're out of time, so thank you, Wesley. Remember, you can't get this information just anywhere, obviously. See you in your TV room next week.